All right, let's get y'all caught up real quick with what fruit of the poisonous tree is because that's very important to continue on this video.
The fruit of the poisonous tree doctrine is a legal doctrine which states that if the source of evidence is tainted due to a violation of constitutional rights, then that evidence, along with anything that is obtained as a result of that tainted evidence, has to be suppressed and cannot be used against the defendant in a criminal case. The classic example is an illegal search of a car that leads to some sort of evidence, say, of drug sales. That drug sales information evidence that was obtained illegally is suppressed, and so is everything that was obtained because the officers found that information.
All right, now that y'all got that caught up, let's really get into it. So here we go. We got Drew, Marissa, we got Brian Steele, and Christy O'Connell. And I want to give Christy her goddamn due diligence because she's been writing a lot of this stuff, and everybody is giving it to Drew and Marissa and Brian when, in all honesty, it's been Christy O'Connell who's been writing the majority of this stuff that we're going through as far as the motion. So I had to give her credit, man. And she's out there in LA killing it. If you know who Christy O'Connell is, you know she whoops shit. Anyways, United States versus Durk Banks. Defendant Durk Banks' motion to suppress fruits of unlawfully seized and searched telephone exhibits filed under seal. Hearing date for August 13, 2026. So they basically go, we here to check on this shit and suppress the fruits of an unlawfully seized and searched cellular phone. Mr. Banks also seeks to exclude this evidence as late disclosed. So they're attacking on two fronts. A very important message from our sponsor, Cloak. Most people who sign up for these kind of services only do it to get rid of those calls. Well, Cloak will keep on doing that, getting rid of the spam calls, but I want to take y'all to the personal right there. They dared me to put my freaking number into it. They said, Nash, we only want to sign up if you're going to sign up with us. I'm already a member because they're showing you all of my information from my goddamn dad's name, my mama's name, to my freaking social security number. See, what happens is billions are made from your personal information. This is how we stop people from stealing our stuff. This is how you fight back, by getting signed up with Cloak today. And the reason why you need to do it, not because they're going to give you 30% off, but because you need to. This is important for your personal information. A lot of us sign up for new things every single day. And Cloak, they're going to continue the fight from day and from night. Get Cloak today, get 30% off. You can hit that QR code or you can tap the link in the description. Get Cloak today, man. Thank me later. The feds know that they're losing this case. If you read anything that came from Mail, from Trapler Ross, from everybody who had visited the dang courtroom, the judge basically like, we getting on with this case because it's clear that y'all don't have shit. And the documents further go on to prove it, because why are you bringing up shit now that y'all could have been had way before and now it's all of a sudden important? I smell something fishy, man. Roll it. So as we start to go down and start to look, start to figure it all out, here we go. On Seti Nash Day, the government disclosed to the defense its draft trials exhibits. Among those exhibits was a text message marked as Government Exhibit 200. That was produced to the defense for the first time. The text should be excluded from the trial in this case for the following reasons. First, the court should exclude Exhibit 200 under its inherent authority to Rule 403 because it was late disclosed, produced to the defense for the first time just 1 month before trial, almost 2 years of diligent defense preparation. This phone had been in the Georgia Bureau of Investigation, that's the GBI, custody since July of 2021, when it was seized from Mr. Banks' home after he was the victim of a home invasion and robbery attempt with reasonable diligence. The government could and should have requested it earlier and thus produced it earlier. Second, the digital device was outside the scope of the Gwinnett County, Georgia warrant pursuant to which it was seized. Exhibit B, Gwinnett County warrant. Under the warrant, law enforcement officers were permitted to seize electronic devices belonging to the perpetrators of the home invasion, not its victims. A law enforcement premises search reasonably tailored to the warrant authority would have included attempting to ascertain the digital devices' owners before seizing them. If the devices were seized by mistake, upon learning that they belonged to Mr. Banks, law enforcement was duty bound to return them to him. Yet they did not, instead retaining it without lawful authority to do so. Third, after unlawfully seizing and retaining the digital device, the GBI obtained a second warrant out of Rockdale County, Georgia, Exhibit C, Rockdale County warrant. This warrant was to search Mr. Banks's digital device, ostensibly for the purpose of determining what other subjects may want to harm him and / steal from him. The warrant on its face falls short of the Fourth Amendment's probable cause and nexus requirements. Fourth, even if that Rockdale County warrant were valid, law enforcement failed to promptly segregate the electronic data that was seizable from that which was not. It then failed to promptly return / destroy copies of data that were not responsive to the warrant. The warrant thus became a vehicle for the government to gain access to data that were no probable cause to collect. Fifth, the digital data unlawfully languished in GBI custody. The FBI waited until approximately 2 years, maybe more, into this case before applying for a warrant. This is an unreasonable and unlawful delay. You know how dirty you got to be to pull some shit off like that. So the feds are basically saying, oh, we going off what the state has said. Because of this shit that happened, we know that possibly that somebody might have hit Durk's house that knew him, which more than likely did know him. The streets know, but either way it go. So Durk owned people set up there and try to break into his house and all this shit and were unsuccessful. But we want to hold y'all shit to see if we can figure out if Durk just shut the hell up for no reason, or Durk shut the hell up because there are people who warned him, we finna come hit your house and you don't want to say shit. This really has to do, as far as how the GBI is taking it, with Durk not actually cooperating with anything. That's what that looks like. That's what that sounds like. That's what that is. So let's go through the timeline to see how goddamn ridiculous this shit actually is. Timeline. July 11, 2021. Mr. Banks and wife contact law enforcement to report the sound of glass breaking as multiple unidentified subjects make unauthorized entry into their home. July 11, 2021. The GBI obtains a search warrant to examine Mr. Banks' residence. The scope of the search warrant includes electronic devices and any other personal belongings the perpetrators may have left behind that would aid in the identification of the perpetrators. During the execution of the warrant, several devices are seized. Once the GBI realized that the digital device in question did not belong to the perpetrators of the home invasion and was thus outside the scope of the warrant, they failed to return it to Mr. Banks. August 19, 2021, GBI obtains a search warrant to examine the electronic devices seized pursuant to the July 11 warrant. The stated purpose of the search is as follows. Due to Durk Banks reportedly being a member of the BGDs in his association with various other factions of the gang, it is feasible that there are a lot of subjects that may want to harm and / or steal from Durk Banks and Cox. This circumstance is compounded by Durk Banks' status as a nationally renowned entertainer / rapper. Also, with the information provided by Special Agent Carter, it is possible that people are seeking to do harm and / or steal from Durk Banks due to the amount of money being offered for retaliatory actions against Dante's killers. The electronic devices that were collected from the scene could assist with the identification of potential subjects who may want to harm and / or steal from Durk Banks and Cox due to the training and experience of your affiant, because I know there's a lawyer that's going to text me and be like, bruh, I told you how to say it, affiant. It is known that the electronic devices can be used for a variety of activities to include electronic communications, i.e. text messages, photos, videos, and voice recordings, social media application communications, global positioning systems, that's GPS information. The devices could assist in the identification of suspects through various forms of electronic messages, the identification of social media profiles / communications. Once a reasonable amount of time for the search has elapsed, the digital devices are not returned to Mr. Banks and Ms. Cox, nor are digital copies destroyed. Instead, they remain in GBI's custody for 5 years and counting. October 24th, 2024, Mr. Banks is charged by complaining in this case. Docket 1, November 7th, 2024, Mr. Banks is charged by first superseding indictment. July 8th, 2026. The government obtains a warrant to search a hard drive containing the forensic image of two iPhones seized from a residence associated with Durk Banks in Brazelton, Georgia, by the Georgia Bureau of Investigation in July 2021. Then they talk about Exhibit D and Exhibit E. July 15, 2026, the government produces to the defense Production 25. The defense is unable to view Exhibit 200, although the government has represented that it is contained in a production. Then July 19th, the government produces Exhibit 200 to the defense among its draft trial exhibits. Then July 20th, 2026, the government obtains a second search warrant, this time to search the iPhone itself. You see what I'm saying? You see what I'm saying? They're trying to say, oh, yeah, Durk, you had threats on your life. Here, give us your phone so we can find this shit. And that's one of the things that people should understand. Majority of the time, the threats that y'all put on people online and shit, it's already recorded. It's already monitored. It's already all of these things. That's why it blows my mind when you dumbasses try to inbox people talking shit, because Lord knows you don't have to say shit. It's more convenient for you not to say anything these days because they're going to go, oh, he's hiding some shit. Why wouldn't he want to do this? Why wouldn't he name a person? He don't know who his ops is? Man, he know who his ops is. Run his goddamn phone. And that's exactly what they did. Argument. Exhibit 200 produced to the defense just over a month before trial should be excluded under the court's inherent authority to manage its docket, and under federal rule of evidence 403, it should be suppressed because it was seized, and that seizure prolonged in violation of Mr. Banks's Fourth Amendment right against unreasonable search and seizures. The court has authority to exclude late disclosure evidence. It talks about cases and all this stuff, and it basically says the government has been investigating this crime for approximately 2 years or more. Mr. Banks has been in custody for this case 21 months. During this time period, Mr. Banks' defense team has been preparing for trial and developing a trial strategy based on discovery timely produced. There is no good reason that the government should have waited until 1 month before trial to seek a warrant for evidence that has been in law enforcement custody since 2021. In fairness to the defense, the court should exclude the government's Exhibit 200 from this trial. Then the digital device in question was outside the scope of Gwinnett County, which they already talked about, and they basically said taken together the elements required officers to conduct narrow seizures that attempt to minimize unwarranted intrusions upon privacy, and go and talk about cases about that. Then they talk about how the warrant was obtained in July 11, 2021, and we already went over that because it is what it is. So they're just basically going through talking about this stuff all over again. So we don't need to revisit all of this shit because it's just repeating things with case law to essentially get it. Because let's just be fair. The feds know that they're going to lose this shit. The judge knows that they're going to lose this shit. So there's that. And they talk about the FBI's delay in obtaining and executing a search warrant was unreasonable under the Fourth Amendment. And that's your rights, your Bill of Rights. You got 10 of them. You should probably look those up. So they just essentially talk about the digital data in this case languished in GBI custody for 5 years before the FBI applied for a warrant to search it in July of 2026. For at least 21 months of that time period, Mr. Banks was being criminally prosecuted in this case, yet the government waited until a month and a half before trial to obtain a warrant to search the device, which sounds effing insane. Conclusion. For the reasons set forth, the court should suppress and exclude from this trial all fruits from the search of the digital data seized by GBI in July 2021 and searched by the federal government in July of 2026. The judge is going to get rid of that shit. I'll be curious to see the response because the feds are going to have to say, no, we been had this. We've been let it be known that we were looking into all of this shit, everything and blah, 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 some more shit. But it's going to be hard. It's going to be very hard for them to slide that shit in there. Adding late discovery like this a month and a half before trial, well, even though trial commences in August, I believe. So y'all doing this shit now, they got to find some type of case law or it's out. You can't do this shit. There's no grounds for them to do any of this shit. See, the feds always, always, always get you by 1,000 cuts. I mean, death by 1,000 cuts. And this is one of those things. So I believe what they found in that phone was Durk talking crazy, Durk talking reckless, Durk saying some shit he shouldn't have said. But not only him talking shit, other people talking shit. Now, if that phone produces a number that had a whole lot of shit, I think that's how they're going to try to tie this in. Like, we were looking for this shit. We already had the damn phone number. We just didn't have the actual phone. We did some digging and we finally found it. But what we found with this number happens to belong to Durk Banks. That's the only way that I see that they can even try to do this shit, by saying we've been giving these guys all type of shit on this phone number in particular. We just had to go search for it and look for it. And then we actually found out, hey, this shit has been with the GBI. We should have been had it, but it's not as though we're now introducing this shit brand new. Y'all been knew about all of this stuff. That's the only freaking play that I can see. And some of y'all go, you giving the feds the idea, man. If you think Seti Nash is more intelligent than the feds at the feds job, man, make me the head of the goddamn FBI right now. I don't want to do this nigga shit anymore. I will gladly say I'll be the head director of the FBI, because if they're not thinking like this and only Seti Nash does, boy, don't make an op out of me. I'm joking. They already know this shit, bro. So the feds more than likely will only be able to say that in order to save the information in my eyes, because there's nothing else. There's literally nothing else. You can't say, oh, we just found this shit. Wait. You just found this shit? So that means you guys didn't do a good job. Y'all rested. Oh, okay. The other alternative. Y'all thought that you guys were going to be able to put this shit back a whole nother year. And that didn't happen either. Huh. Interesting. But hey, y'all let me know y'all thoughts on this one. Nolan Wells got some sick fucking audio that it sounds like these youngins killed him, bruh. If this shit is true, it's going to be a couple arrests happening soon, because it's the only thing that you can do. Click right here for that video, or click right here for the playlist, and get through y'all day on this Monday. I will catch y'all in the next one. We got another video dropping real soon.